Hi folks, I'm Douglas Rintoul, and I recently finished reading an incredibly valuable and insightful book by an experienced law practitioner, The Curmudgeon's Guide to Practicing Law by Mark Herrmann. Now, I'm going to share with you in a series of videos some of the best insights I gleaned from reading this book. To start with, I have a list of 10 tips for how to fail as an associate. Number 10. Give your boss a memo that you know isn't ready. Just label it draft. It'll be just fine. I think what Herrmann was getting at with this particular tip is how much it diminishes your credibility to give out legal work that you know isn't prepared and that will ultimately either force the boss to do more research or lead him in an incorrect direction. Instead, he suggests, come up with your final result and figure out what the boss is going to need to do, and then give him your work. Number 9. Bill an unnecessary number of hours. Herrmann suggests that what all firms and all associates and attorneys in general should be seeking to do is lower the number of hours they bill clients for. So billing lots of hours isn't really what a good law firm wants you to do. They want you to bill the right number of hours for the project that you've been assigned to do. Herrmann suggests that they'd even prefer you bill as few hours as possible, rather than as many as you can, because that shows that you're an efficient lawyer, rather than one who bills an unnecessary number of hours. 8. Forget the facts, just research the law. Remember, the legal holdings in any given case are always dependent on the facts of that case. Therefore, if you don't research and present the facts in the cases you're researching, you're going to present an incomplete picture to your boss. Without the facts, every case's holdings are basically contradictory, and nothing makes any sense. That's what makes the facts so terribly important. Number 7. Forget the facts. Again, just say what the case stands for. This is a problem for the same reasons as number 8, which are that everything is factually dependent. Everything depends on what your facts are in particular. Number 6. Who needs books? I'll just use my computer to find the information. I'm not sure how up to date this particular tidbit is, but Herrmann suggests that you can't find all the information you need just by doing search engine searches, even if you use websites like LexisNexis and Westlaw, because sometimes, for instance, certain items are misspelled or otherwise mislabeled, and if you don't know all the synonyms, you're going to ultimately miss out on some important results using a search engine. On the other hand, if you use books to gather information, they tend to organize things with a greater degree of intelligence. Whether or not I think this is completely right, he clearly has a good point that search engines often lead to people missing important things. Number 5. Get a general idea of the law, but don't bother reading all the relevant cases. Now, this should be obvious. It should be clear why this is a mistake. If you don't read all the relevant cases, then your opponent will find the one relevant case that went against you that you didn't read, and give it to the judge, and that'll be the end of your case, and probably a blow to your career. Number 4. Get a general idea of the holding, but don't bother reading the whole case. Again, holdings and case law are very fact-dependent, and if the judge says something else about the holding in a particular case, you want to know what it was. You don't want to assume that it was still on your side. Those kind of assumptions lose cases. Number 3. Topic sentences, syntax, grammar, that stuff's not important. This is obviously wrong. Lawyers are writers, too. We have to do a good job with that. If your legal writing professor didn't tell you this, learn it now. If a lawyer isn't a good writer, that affects everything else they do. It's a critical core competency that you have to develop. And syntax, grammar, topic sentences, all of these things are important to being a decent writer. Number 2, I was asked one little question. I won't worry about any of the related questions. No, you are a lawyer. You present a holistic view of things. You do not leave things like that up to chance. You do not assume your boss will do all the relevant research by himself. He might not. You do not leave anything to the client to do. They will not do it. You don't leave anything up to anyone else. You do all the research related to the question you are asked to answer. Anything that could be even tangentially related is worth looking into and perhaps mentioning. And finally, the number 1 tip on how to fail as an associate. Don't worry about getting involved or providing feedback. Just wait for things to come to you. This is obviously the absolute wrong approach to take as a new lawyer. When you're an associate, you want to make yourself very useful to your firm. You want to reach out and grab assignments. You want to be aggressive in getting opportunities. Be the person who insists on being helpful. That's how you make yourself valuable. That, along with remembering all the basic legal competencies that are required to be a decent associate in the first place. If you do good work and you look for more work to do, the firm will value you. That simple. I hope you found this valuable and that you'll tune in for the next section on the Curmudgeon's Guide to Practicing Law. I think he has lots of good tips for how to be a good lawyer, and I'm going to keep bringing them to you week after week until I'm done. I hope you enjoyed this, and until next time, have a good one.